Breaking. A financial storm is heading straight for millions of American seniors, and most of them have no idea it's already at their doorstep. Right now, families across the country are watching their parents' life savings vanish into nursing home bills that cost more than $60,000 a year. Homes that took 40 years to pay off are being seized. Retirement accounts that were supposed to last a lifetime are being drained in months. And the worst part, by the time most families realize what's happening, it's already too late to do anything about it. If you have aging parents, or if you yourself are over 60, what you're about to hear could be the difference between keeping your family's legacy intact or losing everything to a system most people don't even understand. Here's what almost nobody is talking about. There is a narrow window of time, and for some families it's closing right now, where specific assets can still be protected before rising long-term care costs eat through them completely. Elder law attorneys are calling it one of the most overlooked financial blind spots in America today. But there's a catch buried inside the rules that trips up even families who think they've done everything right. And we're going to walk through exactly what that is, because if you miss this one detail, none of the planning matters. Here's what's actually going on. Across the United States, the cost of long-term care has exploded. According to reports from senior care organizations, a private room in a nursing home now averages well over $100,000 a year in many states, and assisted living isn't far behind. Medicare, contrary to what a lot of people assume, does not cover long-term custodial care. It covers short rehab stays, not months or years of ongoing care. That means when a senior needs extended care, the bill falls either on their own savings or on Medicaid, the joint federal and state program that does cover long-term care, but
only after a person has spent down almost everything they own. This is where families get blindsided. Medicaid has what's called a look-back period, a stretch of time, typically 5 years, during which the government reviews any transfers, gifts, or asset movements a senior has made. If money was given away, if a house was signed over to a child, if large withdrawals happened without the right legal structure in place, Medicaid can penalize the applicant, delaying their eligibility for care by months or even years. Families who thought they were being generous or simply passing down what belongs to their kids anyway often find out the hard way that the timing and the method matter more than the intention. So which assets are at the center of this? Financial planners and elder law attorneys point to 3 in particular. The family home, which for most seniors is their single largest asset and the one most vulnerable to being counted against them or clawed back later through estate recovery programs. Retirement and savings accounts, which can be drained rapidly once care costs begin, sometimes within a year or two for a couple facing dual care needs. And cash or liquid assets that families assume are safe simply because they're not real estate, when in reality they're often the first thing counted during a Medicaid asset assessment. Now, here's the twist that changes everything. Many families believe that simply transferring a home or accounts into a child's name protects it. It does not, at least not automatically, and doing it incorrectly can actually make things worse, triggering the very penalty period we just talked about. The real protection tools that elder law professionals point to include irrevocable trusts, properly structured well before care is needed, spousal empowerment protections that allow a healthy spouse to retain a portion of assets and income, and certain exempt asset categories that vary state by state. But none of these work as a
last-minute fix. They require lead time, and that lead time is exactly what most families don't have because nobody warned them soon enough. This is where the real damage happens, and it's not just financial, it's deeply personal. Picture a family who spent decades building equity in a home, only to watch it get sold off to cover a parent's care because no protective trust was ever set up in time. Picture adult children who suddenly find themselves financially responsible or emotionally torn, watching an inheritance they assumed would come one day disappear into monthly invoices from a care facility. Picture a surviving spouse left with barely enough to cover basic living expenses because the household's combined savings were drained covering a partner's final years of care. This isn't a rare, isolated situation. It's happening in ordinary households in every state to people who worked their whole lives and did everything they thought was responsible and simply were never told the clock was already running. And there's a legal risk hiding underneath all of this too. Improper transfers made in a panic after a diagnosis or a health scare can be flagged during Medicaid review and can even raise questions in cases involving multiple heirs, especially if one sibling receives assets and others don't. Disputes like this tear families apart at the exact moment they should be pulling together. Elder law attorneys report a rising number of cases where siblings end up in court fighting over a home or an account that could have been protected cleanly years earlier if only the planning had started before a crisis hit rather than during one. So where does that leave families right now, today, watching this? The uncomfortable truth is that waiting for a health emergency to think about this is often waiting too long. The 5-year look-back period means today's decisions affect eligibility years down the road, not next month. Families who start early, who understand which cancers are exposed and which protective structures actually hold up, are the ones who come out the other side with something left to pass on. Families who wait are the ones who end up liquidating a lifetime of savings in a matter of months, watching their parents' financial dignity disappear along with their health. But here's what almost nobody mentions, and it's the part that changes the entire calculation for so many families. There are specific circumstances, certain state-level exceptions, and particular timing strategies that can still apply, even closer to a care event than most people realize. Situations elder law professionals describe as narrow but real. What those exceptions are, which states currently offer the most protection, and the one mistake that disqualifies families from using them even when they think they qualify, that's the part most people never find out until it's already decided for them. If your family hasn't had this conversation yet, the next few years may determine whether your parents' home, their savings, and their independence stay protected, or whether the system makes that decision